Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Had the matter, styled as Idaho versus Kohberger, gone to trial, what you would have seen if you would have watched the proceedings would be the presentation of the case in chief during the guilt phase, or the case in chief phase, as I like to call it, presented by the state of Idaho, because they had the burden of proving, based on all of the admissible evidence that was entered into the record and that the jury was able to see and hear, to persuade that jury of Mr. Kohberger's guilt and beyond a reasonable doubt. Once the state rested its case, then the defense would have presented its case. Then once everything was done, once both parties ended their closing arguments by the state, and then the defense, and then rebuttal closing argument by the state, once all of that was concluded, then the next important step that would have happened would have been Judge Hippler turning to the jury and reading them instructions of law. Sometimes there's a large stack of jury instructions, other times there's just a few. What had happened here with this party's proposed stipulated jury instruction is that during the motions in limine hearings that happened back in April, one of the issues that were brought to the attention of Judge Hippler was the defense's motion in limine regarding Riley Nolan and touch and contact DNA. The court rendered an order, as we see on page number 1 here, directing the parties to come up with this proposed stipulated jury instruction. And what this means here is that in conformance with the court's order, as you're seeing here on page number 1, the parties, if you read the order, were directed to get together, come up with some sort of an agreement, which is what a stipulation is, and submit it to the court. So let's take a look at what this document says. First and foremost, if you would like to read it, it's one of the recently unsealed documents from April and May of 2025 that were previously under seal, therefore not accessible by the public. It is now. You can find this proposed stipulated jury instruction on the docket, filed May 30th, 2025. As we see here, both parties are signing this document, Mr. Thompson for the state, Ms. Taylor for the defense, and this is referencing the court's order, as you can see, of April 17th, 2025, and it has to do with the defense motion in limine. What's a motion in limine? Always a good opportunity to say a few words regarding that. Well, we know that a motion is an application for a court order. It's one of the parties coming before the court seeking some sort of a remedy. Motion in limine means it's being done before trial. They want a pre-trial ruling on an issue of importance. In this case, it was the defense's motion in limine as to Riley Nolan and touch and contact DNA. Ms. Nolan is a management official with the Idaho State Forensic Lab, and she gave some testimony back in January at the motion to suppress evidence hearings. That transcript of her testimony is available for you to review. It was filed in February of 2025. If we go to page 2, this is entitled Parties Requested Instruction Number in blank, because at this point in time, May 30th, it's unknown. Is it going to be jury instruction number 13? Is it going to be jury instruction number 23? That would be something that would be determined once all the jury instructions that were approved were then assembled and then put into some order, so that at the end, closing statements Judge Hippler would then turn to his stack of jury instructions and begin reading them one after the other to the jury. Now this, what you see here, as with all jury instructions, if this instruction was approved by the court, it would be the court reading this to the jury. So bear that in mind as we go through this party's requested jury instruction number and blank. And it reads as follows. During testimony, you may have heard certain witnesses refer to touch DNA or contact DNA or trace DNA. To the extent that those terms may have been mentioned by a witness, you are to disregard that particular term and not give it significance as you consider the evidence or testimony related to the use of the term. And the proposed jury instruction ends right there. Now, if I could make a comment and provide an opinion, give some speculation here. If you followed the case of Idaho versus Kohberger before its closure, or if you became interested in it after it was closed in July of 2025 without a jury trial because Mr. Kohberger pled guilty to the 5 counts that he was going to face trial for, you know that the issue of DNA was extremely important in this case. There were many hearings that were held. There were many motions, responses, replies that were filed. There was a lot of back and forth. It was an issue that at many times, particularly when it came to IgG, DNA was extraordinarily hotly contested. So this is, in my opinion, a big deal when anything is having to do with instructing the jury on DNA. Here, it's possible that what the parties had in mind was Rylene Nolan, because she was definitely going to be a witness. She was actually on the witness list for the state, was going to be presenting testimony. She was involved in the case. She didn't do the actual forensic testing, but a member of her team did. So again, very important jury instruction had this matter gone to trial. Everything that we present here, opinion, speculation, commentary based on the record. If you have any thoughts, any opinions, any comments that you would like to make relative to this jury instruction, please leave them here. And until next time, my name is Kathy. Thank you very much for joining us here today.